Hello, everyone. Thank you for joining us today on LNC Talks. My name's Tim Kane. I'm the CEO and president of Medical Legal Connection. And this is a little show that it brings together people in the medical legal world. And we chit chat about medical legal issues and just throw the ball around in a casual manner. Today with me, I have a couple, my normal guest is Jennifer Leahy. She's my vice president of operations. And my very special guest is an attorney here in Buffalo, New York. We're actually in Hamburg, right outside of Buffalo, right near the Bills Stadium, is Blake Zaccagnino. And he's a member of Shaw, which is a personal injury firm and also deals with medical malpractice. Thanks for joining us, Blake.
Thanks for having me.
You're welcome. It's our pleasure.
It's a little cold today, but that's what makes this all the better instead of a sunny 80-degree day.
I know. I'm going to Florida in a month, so it'll make it worth it. We're just going for a couple days to see my wife's grandparents, but yeah, it makes you appreciate the nice weather.
You just get to take your coat off, you know what I mean, and not have to have it on and be outside. It's just an amazing feeling.
I know.
Side story, tomorrow, I'm going to Canada for the break. We're going to Great Wolf Lodge.
Ooh.
That'll be fun.
That's an indoor water park. And I'm just looking forward to getting into a pool that's just 84 degrees. I don't care if it's inside.
Warm
and humid. Tropical. Whoops, sorry.
Yes.
No,
but it's tropical in that pool area.
Yes.
Oh, yeah.
But anyway, so this is just an easygoing conversation, and let's interrupt each other because Zoom is kind of, cuts over the top, and we'll just keep rolling. So Blake, tell me a little bit about Shaw.
Yeah. So, I work here, and my dad and I are the ones that do all the personal injury cases, and we have my brother's here, and then we have another attorney, Jennifer Burke. And my dad and I do all the injury stuff. My brother and Jennifer Burke do mostly real estate. We did have a more general practice where, we had someone that was doing wills and all that stuff, but we've gotten a lot more specialized over the last handful of years, I think, since the pandemic, because, I'm sure this could lead into how you guys have helped me immensely on our cases, but it seems like these issues in these cases are getting so specialized that you really don't want to be a generalist, and you want to make sure that you handle the same type of case all the time, or the same type of cases, so that you can see what issues are coming up, know what experts you have to consult with, and all that stuff. So yeah. And as far as on the injury side of things, we generally handle mostly car accidents and slip and falls. We do some med malpractice. Not a ton. We do some, and we do some product liability. And then over the last handful of years, I've had a number of constitutional cases, so excessive force cases of improper treatment in jails, or when someone was arrested. And I have had a few medical malpractice cases over the last couple of years, which you've helped me with as well.
Awesome. Yes. The personal injury, of course, everybody that's, gets involved in the legal side of a personal injury case winds up going to that dreaded independent medical exam. And to a lot of people, they don't really understand, what that's about, or they get confused and scared. And I go along with your clients and to some other clients and just go there as a witness on their behalf and just kind of support you as the attorney in there. How I got started, though, is interesting. You and I have talked about this. I believe I'm sure in my audience here, I have a lot of legal nurses listening, or at least watching later. I took a course for training to be this legal nurse consultant. They didn't teach us a thing about independent medical exams. Nothing. It was all med mal, and that was it. And they teach you how to do all this marketing. And so back in 2011, 2012, I sent out a bunch of emails. And one of your paralegals answered me back, and she said, we really don't need med mal chronologies, but would you go to our independent medical exams? I was honest. I'm like, I would love to, but I have no idea what that's about. She goes, come on in and let's set up a time, and I'll give you the highs and the lows, and it would be great if you could do that for us. And that's how this company, Medical Legal Connection, started. I mean, a couple other firms came after that, right after. She even referred me out to a few, but the IME world, my point to a lot of people, unless they wind up filing a suit, don't have any idea what it's about.
Yeah, and Tim, do you find yourself going more to the defense medical exams when a lawsuit has actually been filed and the defense doctor is examining them? Or do you go more often to, for example, if it's a car accident, like a no-fault independent medical exam through their own insurance carrier, or do you guys do a combination of the two?
That's a great point to bring up. I kind of do a combination of both, but the majority is the litigation exams. You know, that you know, the exam notice comes right from a judge. But I do have a couple of clients here in Western New York that send me to all their no faults on top of it. It's attorney preference, because I sit in a waiting room and there's a couple of attorneys with clients, and then there's so many people that are going to that no fault IME, and they have no one, and they don't realize, you know, that there's a benefit to it. So, but no, the majorities are IMEs and DMEs.
Yeah, and it's you know, we found it to be crucially helpful on the defense medical exam. So just for the context, which I know that you know, but lawsuit is filed and the defense wants you examined by their doctor so that they have an expert medical person that's involved in the case. And it's important to have someone in observing that's not a part of the attorney's firm, because it's an independent source that can say, okay, this doctor took 15 minutes and then wrote a 30-page report basically stating that the person was not injured. And we haven't personally done it, although we've discussed that in our cases where you've helped us and that might go to trial, they actually bring you as a witness to the stand to present in front of the jury to say, who do you find more credible? This person's treating doctors that have treated them for a year, sometimes multiple years, that have formed this opinion, or this defense doctor who, per the expert witnesses said, was in there for 10 minutes and wrote a 30-page brief, you know, or a 30-page report.
And, you know, sometimes, and I've discussed this with Jen, I mean, they even, like, Jen's attended a few IMEs as well, along with the med mal. They kind of come to that. You could even get the gist in the IME from some docs will already have that conclusion done before we're even out the door. Yeah. And I'll note that. And it's funny you say that too. I've done a lot of affidavits for firms on IMEs, and they keep saying that we're going to call you in, and then I hear it settled. And I just think that's the strategy. You know, we'll bring this person in, and then the other side must think about it, and then they decide to settle.
Yeah, and you know, the way that I like to think about these cases, you know, and I guess we can just use car accidents as an example, although I'm sure it applies to many claims. But the way I like to look at it is, which it's true, it's an insurance claim. So all sides are wanting to get as much information as they possibly can to make the correct decision, whether that's to pay a fair settlement, to have it go to trial and let a jury decide. And I've always been of the mindset to get all the information out there and provide more information to try to show the insurance company, this is the evidence that we have, and this is why we feel this number is a fair number. And ultimately, that's really what it is. I truly believe that everyone just wants a fair result for all parties, and they just they want the information to be able to make the right decision. And you guys are just super helpful in providing that.
It's a support, I think, that is pivotal to a lot of these clients, you know. So other than that, yeah, IMEs, DMEs, we've done some med mal, and we've done some med mal for your firm.
Yep. Yeah. It's been crucially helpful because in a med mal case, there's a requirement to have a certificate of merit that has to be filed with the complaint that basically says that you consulted with a physician expert in the field and that physician feels that the case has merit. And I'm not again, I don't handle a ton of those types of cases, but I think the idea was to weed out non-meritorious claims. And you've helped us get connected with experts within the field that we need to then allow us to obtain that certificate of merit, which is essential to the cases, because a lot of the times, without it, or if, because I think there's a section as well where it says that you made 3 good faith attempts and you weren't able to consult with one, and that is good in some circumstances, but it's crucially important to obtain that if you're able to do it.
And that's what we do too, Blake. I mean, to kind of, when you give us a case to see if it is, has merit, we as the legal nurse consultants will go through it to see if, what experts you need, and then we can find those experts for you. And then we bring you options, and then you can interview them and decide for yourself who you'd like to go with for your case. And we enjoy doing that. And
we have a ton of avenues. We just don't, I originally started out, Blake, you need an expert? Well, let me look on social media and hope I'll cross my fingers for you. Now I have some other, I've paired with other companies and other people that I'm getting access to Rolodexes, and people are getting access to my Rolodexes. And we have a plethora full of experts now, a lot. So, but they come from different directions at us. It's just the point I'm trying to make is just not one direction anymore. Just, hopefully little, LinkedIn post, and hopefully they'll, respond. There's a lot of ways to get experts. It's just, using someone like ourselves just to get that for you and make it easier and support your case again.
Yeah. And I know that we briefly touched on it when we were off the recording, but what I like personally, I know some attorneys have a different attitude about it, but I like to have, even if I'm able to send you, for example, if it's like a medical issue or a medical malpractice case or a civil rights case involving medical care, I like to send you all the records at the outset, even before we've gotten deep into discovery, and even sometimes before we draft our complaint, so that you can either give us your thoughts or give us an opinion early on, and or say, I don't have the expertise, go to this person. So then I can then frame all my paperwork, and it can inform how I build the case moving forward. And it's just so important, because we don't have the expertise, and what we as attorneys say on medical issues, it doesn't matter. So it all comes down to the treating doctors, the defense medical examiners, or your own independent experts.
What we promote to law firms is we'll give your case the smell test, and if it passes, we'll tell you how, and if it doesn't, we're going to tell you how to. And we've told many firms that you really don't have anything here, and they come back very appreciative. It's like, okay, thanks. That's we're going to decline this case and not spend any more money on it. Because you guys have shown that it doesn't have it, or we have shown that it doesn't, and they love that.
Yeah, and then we can at the very least then feel comfortable having the conversation with the client and say, look, we dealt with experts, we sent them the whole file, this is their opinion, and then let them make the decision. But you feel better because you're not guessing at anything, and you've at least done your diligence. And I know that we talked about this too, but my big thing, and I've noticed in the law, and I'm sure medical is probably very similar, is that it's not like a math problem where it's the same A plus B equals C.
Right.
There's not one right or wrong answer on a lot of these questions. So it's just doing your diligence and then making the best decision that you possibly can.
Absolutely.
100%.
Yeah. It all depends on each case.
If anybody out there wants to ask us a question, sometimes they do, sometimes they don't, please type it in the comments. Even if it's just a comment and not a question, we'd be happy to address it.
Yeah, and what I've noticed and what I like about the expert reports that we've gotten from you, from your offices, is that you review the file, and you could obviously comment on what is on the page and what was documented. But I like that you're also able to read between the lines, and a lot of times, and state, okay, they failed to document this or they failed to document that, and that tells a story too, which is really important. If you could show that, okay, I'm a nurse, I've been in these situations, and what I'm getting from this is X, or what I'm getting from this is Y, and what the person's motivations might have been, or kind of if they followed procedure or not. I think that's really important.
When we do chart reviews, we put ourselves in the shoes at the bedside. And and so then them questions pop up, right, Jen? I mean, you've done that a million times. Yes. And then we ask them.
Well, you try to compare it with the standard of care. I mean, in this situation, what would the nurse do? What was reasonable and at this time? And that's really what you base it off of. Or if there's protocols, make sure they follow protocols. If things were reported in a timely manner. Lots of times you're busy, vital signs were missed, or, I mean, things are going
we hate to be the Monday morning quarterback, but that's basically what it is.
Yeah.
Because you see the lack of documentation, and then that screams volumes, the lack of it. It's like, okay, you had this problem. Why did you not go down the list of the A, B, or C, or D, or what any other person would have done? And it's just not in the record. And then that's what you show.
Yeah. And, we've had a lot of, so in car accident cases, and I don't know, I'm sure that you're somewhat familiar with it, but because of the no fault laws, meaning and this is for New York, regardless who was at fault, the car that you were driving at the time of the accident will cover your basic medical, and then the pain and suffering and anything that's not covered through no fault comes from the at fault driver. And one of the requirements to get money from the at fault driver is you have to have a qualifying injury under the law, and it's a complicated statute, but there's a number of different types of injuries that qualify you and get your foot in the door. And there's clear categories like a fracture. If someone has a fracture, any judge could look at that and state, okay, they have a qualifying injury, so now I can look at everything and determine what's the value. And then there's non-clear-cut categories that deal with the disc herniations, the soft tissue injuries. And in those situations, what the court looks at is objective injury, range of motion, and then documented limitation of activity over a long period of time. And it's extremely helpful to have an expert opinion on those issues too, because a lot of the times what happens, and I know that we talked about summary judgment, but at the end of the discovery process on these cases, the defense will often move that's called for summary judgment, which is basically them asking the judge to look at all the evidence and just dismiss it without a trial.
Right.
And all that you have to do is show the judge that there's an issue at fact, or there's competing affidavits, or there's witnesses are saying different things, one in support of one side, one in support of the other. Then the judge says, I can't resolve issues of credibility. It has to go in front of it has to go to trial. And what's crucial to responding to those motions is expert opinions.
Well, and it goes back to with the witness in the IME again, and I might have said this earlier, range of motion, like my reports will get real detailed on that client's range of motion, and it forces the doc to know that I'm going to do that, and he knows he has to be close, or he knows my report's going to come in. I don't have the education to dispute his opinion, but if I say, Mrs. Smith's range of motion was minimal and complained of pain, and he says, well, her flexion was acceptable at range and no discomfort noted, there's a problem there, and that's where the witness is imperative.
Yeah, and now that I'm thinking about it, that could possibly create an issue of credibility that would then inform the judge to say, I can't just dismiss this. There's, because a lot of the times there's something called the battle of the experts, which means one expert says one has one opinion, the other has another, and the judge will say, I can't. That's up to the jury to say who's more believable. So it has to go to trial. And oftentimes, and we talked about this, oftentimes, if you can overcome the emotion is when you're able to settle the case, which is ultimately what you want to do. You don't want to be in trial. I mean, if push comes to shove and you have to go there and they're not being fair, then you go there and you fight. But the ultimate goal is to everyone come to a settlement.
Mm-hmm.
I had a nurse call me, a DME nurse I have the training course. Long story short, she calls me in panic. She's like, oh God, Tim, they're going to call me to testify. This is what happened. she went to an IME with somebody. The doc asked if they had any, I got to remember what she said, if he had any prior sports injuries or sports related issues in the past. Or no, if he did heavy labor, excuse me, and his job was heavy labor. It was something to that point. And he told the doctor no. And the doc's report to the defense attorney was that this injury came from this guy's working hard labor or something like that. And her report says the opposite. And she even has the notes that say that. So they're going right to like, okay, this is what he's saying, this is what she's saying, and they're gonna let that judge just like you said, he'll probably throw it in front of a jury.
Yeah, and it's important too because it's, what was I gonna say? I might have lost my train of thought. But yeah, I mean, just noting those little subtleties, and then to show the judge it's not so black and white here. It has to be, put it in front of the jury and let them decide.
I have one question from a nurse out in our little audience.
Sure.
Let's put it up, and this is for you. Janet?
Yeah. There is a list, and now this would be for New York State. I'm unsure of other states, but in New York, I think it's Insurance Law 5102D. So you could Google that, or you could Google NY.
She's in Florida. I'm a little familiar with Janet.
Oh yeah, no, I'm not familiar. Yeah. But I'm, just for an example, if you wanted to see the New York one, you could type in go to Google and type in NYSBA, like, New York State Bar Association, and then put serious injury threshold, and they put together a really nice summary of this.
Oh, good to know.
It's good for us to know. Yeah.
Absolutely. So. Great tidbit. Great question.
Yes. Yeah. Thank you, Janet.
And it's, is there a certain type of case that your office handles regularly, or is it all different types of cases that you're?
We accept every single possible case. We have an oncology nurse, we have a PhD nurse who's a provider of care at the hospital that's about 3 miles from you. I have cardiac nurses. We have pretty much access to any nurse and physician assistants too that have told me, like, if you want us to review a case just to see if it passes a smell test, we'd be happy to do that. So my answer to that is there is not a case that we cannot accept based on its what area of the medical world it hits. Nursing home, oncology, orthopedics, especially neuro, pediatrics.
I was going to say.
We just found a local firm in Western New York, a pediatric GI expert.
Mm-hmm.
Going forward. So we're open.
And I can say from our end of things, and what we tell people a lot is, especially if it's a car accident case, the key thing is for them to get treatment and get consistent care, because that's what the court is going to look at. And if they want a fair settlement, you have to, listen to your doctors and get over and be consistent and have it documented. And it's what I found, it's difficult for a lot of people to understand. They think, okay, well, I was at a stop and hit from behind, so it wasn't my fault, so I should automatically get money, but they don't understand there's certain barriers and things. And is documenting a huge part of the medical field and being accurate and all that?
Well, we say in the medical field, if you didn't document, it didn't happen. So that's kind of, in nursing school, that's what we've been taught from day one. So you always want to document. And then to what you were saying too, Blake, it's like, if, you have this injury, this car accident you bring up, you want to make sure that that injured person is compliant with treatment, because sometimes, they go, or they, maybe sometimes they malinger, or, they had this car accident, and then they want pain meds. And then if the doctor realizes that they don't need pain meds, this is an acute injury and you shouldn't need it after like 5 days or whatever. And then they go to another doctor and they look for pain meds. it all depends on each case and what that injured person is doing and how they're treating, and are they responding to treatment? Is the doctor listening to them? Maybe they need a specialist, specialist in terms of if it's a neck injury. I mean, you got your ortho injury of maybe like musculoskeletal pain, but maybe they had whiplash and maybe they got headaches, and then you maybe want a neurologist. It all depends on each case, and then absolutely looking at the records and what's documented, and looking at the provider, and then looking at the injured person. I mean, what's
to ride that coattails a little bit about the nursing documentation.
Mm-hmm.
We have found this, and I'll always say this when we review a case and we go, a lot of times my first stop is the nursing notes. Nurses are more than happy to throw a doc under the bus if they think he's doing something wrong, especially if they've even brought it to his attention and he or she is ignoring them. They will go right to a progress note and, advise doctor such and such, patient status declining, vita sign such and such, and this and this and that. And they'll teach us how to do that. You don't say anything derogatory. You just say, doctor such and such advised of this situation, no orders received. That screams to me, the legal nurse consultant, this is a person that this attorney's going to want to talk to because she was there and she was already smelling the badness going on.
Oh yeah, and that's a crucial thing too in our cases, is finding witnesses that have personal knowledge and that, good or bad, you want to know who's the most relevant person to talk to, because ordinarily how it works is, for the first depositions that happen, which is question and answer before a trial that happens, it's usually in front of a court reporter, stenographer, and it's sworn testimony. And really that can make or break the case, how those depositions go, because if the case ends up going to trial, then, you've probably heard it on TV, but they'll say, okay, if you're questioning somebody on cross-exam, you don't want to ask a question that you don't know the answer to. Well, the way that you know what they're going to say is based on what you asked them at the deposition. So it really, because if they waver or say something different, you just say, didn't you say on this date under oath that ABCD? So, but yeah, it's finding those witnesses is crucial. And I know that you've helped me with that on our cases too, to say, okay, you should talk to this person, or this person would have the best information, or based on their note, this would be a good person to talk to.
Not to go back and forth on topics, but what you were talking about with the IMEs and getting proper care and getting medical care and have it consistent. I see a lot of IME docs, eyes will light up. Somebody will be in a rear end crash, their neck and back hurts, and they didn't report it or seek medical treatment for a month, 6 weeks later. Defense doc, they're going to go all over that. I'm like, oh boy, that's going to be a problem, and that happens so much,
Yeah, and what?
Treatment.
Yeah, and I feel like a lot of people, and I'm probably the worst. I got a primary now, but I haven't been to the doctors, and I'm one of those people, but. I'm going to get back on track with it, but I think it's tough for people because they've never been involved. Most people have never been involved in, for example, a car accident or this type of incident, and they don't understand the importance of getting that care right after the accident happens, because that will be important when you're looking at it down the road of causation of injuries, to say, okay, on the day of the accident, they complained of these things and they were diagnosed with these things. So that helps with causation. But also there is something for car accident cases called a gap in treatment, where if there's a substantial gap in treatment, and there's case law on it, I'm not exactly sure the exact months that have been out there, but the bottom line is, if there's been a gap in care, the case could also be dismissed because of issues of causation, and relating injuries back. And the other, you can give a reasonable excuse as to why you had the gap in care, but yeah, that could be really detrimental to someone's case. But what we found is just getting in with somebody right away. I mean, obviously your primary if you can, but we've seen people be successful with chiros or PTs just getting in right away, and they can start the documentation process and at least get them evaluated and then refer them to a higher level of care. Have you found that people have trouble getting in a timely fashion with the, like they go to the ER, then they can't get in with their primary for 2 months, and
or sometimes they'll get him with a chiro, but now this kind of opens up another worm, a can of worms. They'll say, I got in with my chiropractor. So now you're saying you have previous back injury. And then I know the doc's going to say, okay, why do you have that chiropractor? Well, my back. Oh, well, then, but yeah, I to answer your question, they will ask some friends or even, I don't know. Let me ask you this. I cringe when people do this, and I've never had a chance to ask a personal injury lawyer. They'll say, I went to my chiropractor, and the doc will say, well, who referred you to that chiropractor? My lawyer did. I don't know if that's not a good thing, bad thing, but I just don't get a good feeling from that.
I don't think there's any rule against it. I mean, I think you can reasonably state that, hey, I know that this type of doctor, whether it's a chiro or a PT, handles these types of cases all the time. They understand the documentation process and all that. But yeah, I personally haven't seen it come up at a trial where they say, okay, you're at this doctor. And I mean, my good friend, Dr. Frank Michalski, he's at Northtown Chiropractic, and we'll do similar videos like this, informative videos. And I could definitely see it being brought up at a trial at some point. But aren't you friends? Don't you guys do those on social media? But yeah, I haven't seen that come up. But yeah, I could definitely, I get the cringe thinking about that too.
Yeah. So I've never really looked at it. That's a good answer. I got a couple more questions if we're
Sure.
Let's do this. We got Janet, we got a few other people, but we're gonna stick with who came first. Hold on.
Okay.
All right, our comment. We'll do this. Interesting that being hit from behind isn't an automatic claim to get money. What circumstances would change that, perhaps?
Yeah, so on the liability, so yes, if you're at a complete stop and hit from behind, and this is for New York, there's a presumption that it was the fault of the rear-ending car. So that would be from liability. But what I meant by that was on the damages side of things. So the injury side is, even if a person is, a lot of times the defense in those types of cases will say, we agree, we were 100% at fault. However, they don't have an injury that is in one of those qualifying categories. So it's more just on the damages, the damage, meaning the personal injury side.
Right. Not the no fault.
Right. Or property damage.
Right.
Yeah.
A different mechanism cause, such as a car hitting from behind, was hit themselves. I'm not so sure what you mean by that.
Different mechanism causes, such as the car hitting from behind, was hit themselves.
We might have been talking about something at the time, and then
is it like a chain reaction?
Maybe.
Oh yeah, maybe. Yeah. And those are always interesting cases too, because one of the ways that, oftentimes you'll see the argument that, the car had made a sudden and abrupt stop. So I've seen that argument where, let's say your client was involved in, like you said, a chain reaction sort of thing. We've argued, and the testimony and proof comes out that the lead car made a sudden stop. The key issue that the court will look at is whether it should have been expected that the person was going to stop. So if you're coming towards a red light or something, you know what I mean? But yeah, very often there's, even in the hit from behind situation, if it's a chain reaction, oftentimes there's different questions that come up on who was at fault.
I've been IMEs where they're all rear ends, but it's sometimes 4 cars are involved. It's one hits the one, then he hits the one in front of him, and then he hits the one in front of that, and then I don't know how they sort that out. But do you have a lot of witnesses chow out, or is that bow out? I'm sure, say maybe you have witnesses no, I'm not going to do it. I'm not going to be your witness.
Well, we can subpoena people to come and testify. And I mean, what I have found, people are mostly honest.
Right.
I think I really do. That's from my experiences of doing, doing a lot of depositions. And I know that you guys are the same way. I mean, I approach it just because I'm more of a easygoing person. And so I'm not super aggressive with people. And I found that whatever the saying is, you get more, what is it? Tea with honey or sugar? I don't know. Tea. Yeah. Something like that. You get
you collect more bees with honey.
Yeah. Tea. Yeah. What am I saying? But, yeah, no, it's so true. I found that if you're kind and respectful but still being an advocate and asking questions, they'll respond with kindness and will be more open than if you come at them really aggressive. I don't do that. I think it's counterintuitive. Have you guys noticed that in the medical field with dealing with patients? It's, I'm sure you've dealt with patients that are more challenging or difficult or giving you a hard time. It's not responding with the same energy and just being.
How about 80%?
Yeah.
Well, and I always think about too, first of all, if a patient in the hospital, that's not normal for them. They're there for a reason. As a nurse, we work there, so we're comfortable there. That's our environment that we work in. For a patient, not so much. I mean, comfort would be being at home in their own bed and doing their own thing. So clearly they're nervous, they're out of sorts, especially whatever's going on with them. So rightly so. I mean, you just kind of give them some support. You give them support and help them out and explain things to them and kind of calm them down. And that usually helps too. Put them at ease.
Yeah. We got Joanna. Thank you for talking to us today. May I ask you, how'd you compare handling cases before you used LNCs as opposed to now? Have you heard of LNCs before? Tim contacted you. Yes and no. Like I told the Gail story. I didn't even think that was before you were even in the picture. I mean,
yeah. Oh yeah. Yeah. Yeah.
Yeah.
Funny is I shifted to putting content on LinkedIn because, I followed Gary V, that marketing guy, Gary Vaynerchuk, and he had said a couple of years ago that LinkedIn was becoming the platform that was had the most potential for organic reach. Where TikTok used to be really organic, but that was his prediction. So I started going on to LinkedIn and I noticed a lot more. I had heard of LNCs prior, but I had never had a lot of involvement. But then I was getting a lot of my connections and requests were from LNCs,
Oh, and, sure.
Yeah. And it's invaluable because, like we talked about, which I don't know if we did when it's been on the live, but we don't, as an attorney, unless you're a doctor, you don't have knowledge on these types of cases. And we're really relying on experts to look at it and give us an independent review.
Right.
And an honest opinion. And that's all that you want is you want honesty. And if the case doesn't pass the smell test, you want to know early on so that everybody knows.
That's the pivotal part. I mean, it's the money savings are worth it to go forward.
Well, just to support what you're saying, Blake, it's like nurses know how to go through medical records. We know what to look for. We know what the language is. We know the abbreviations. We know all that. You as an attorney, you know the law. So when we partner up together, then we can build your case and really knock it out of the park and do your best that you can and hopefully achieve your best outcome possible. So that's why we partner up and we learn too. We teach you about the medical records and abbreviation and medical terms and what we're looking at. And you as well, you're teaching us about the law. So it works well together.
It's a win-win.
Yeah. Yeah. And I think what you said there about the medical chronologies and summarizing the medical records, I think that's huge. I mean, at our office, we have our paralegals that are doing it and they do a great job. But I definitely want to look into utilizing that service because where it helps is it helps us if we get calls from an insurance company because so generally how these accidents work, whether it's a fall, whether, really any type of case where there's insurance involved is you put everybody on notice, you send them letters, and then generally the first year or more, the person's getting treatment and you want them to get to the point of maximum improvement or they're done with care. then send the entire package to the insurance company so that they can see it as a whole and, give an evaluation. But in the interim, where, while the person is treating, we'll get calls from the insurance company and they'll say, hey, where has this person been treating? What are their injuries? And I know with our chronologies that we've had our paralegals do, it's really helpful to just jump on and be able to see, okay, yeah, they went to these doctors. These were the soap notes or whatever. But yeah, I mean, that's extremely helpful. And then I think I've even noticed it's probably more helpful on the defense end because, like they're the ones at depositions that are asking a ton of questions about the person's medical background. And a lot of times hundreds of pages of medical. And I've noticed that they'll have a little cheat sheet that says that will kind of summarize it for them. But yeah, I mean, it really saves a ton of time.
Yes. Well, especially in those chronologies, you want to know what any pre-existing care or treatment that occurred, and then you got the accident, and then you document all that. And then it tells the story from the time of the accident to where they are in present day. And then you can formulate, sometimes maybe maybe their injury did resolve and they had good healing, but they're still treating. And, or maybe they didn't have a good outcome, or, there's complications. I mean, you can do everything right and still have a bad outcome. So again, it just depends on the case.
Jen and I may have touched on this earlier, but I love paralegals. Okay. I'm going to say something we do chronologies that are not copy and paste. I'll get a ton of law firms will send me their chronology from their paralegal, and it's wonderful, but they went through the record and just copied and pasted everything. We'll give you entries, what we find from the record, but we'll also give an analysis with it and an opinion on it, where a paralegal can't do that. Because so many attorneys will say to me, oh, chronology, I'll just have my paralegal do that. But I'll say, there's more to it than that.
Yes.
Yeah. And you're springing it in my head too, because we have these other cases that we handle that are more medical intensive, where the questions that we ask of the client, we're the ones asking questions about the medical. And I've had it where it's been like 3 boxes of records and you're just going through and trying to pull out all the relevant stuff. And it's really time consuming. And as you guys know, it's really hard to find long stretches of uninterrupted time to get work done. So I'm aware that we can save time and have it done in a manner that's more detailed and more informed. I'm game for that, I'm very interested in that.
And I think hospitals love to bombard you with medical records that have zero relevance. You'll get all the billing sheets, or you'll get like the dietary orders for the day or something. And that's all. See, I put that aside, and because I already have an idea of what areas I want to zero in, where a non-medical is going to go through each one of those pages and see what it says.
And it's funny too, because it seems like going through, for example, if it's a Chiro's notes or PT's notes, or even an orthopedic, you'll have the main intro or start of care page that is really detailed and goes through everything. And then it seems like a lot of the stuff just repeats. So being comb through or not miss anything. So I found myself a lot of the times, if I'm going, and I don't mean to keep going off on tangents, but
no, do it.
There's a document that we do called a bill of particulars, and basically in state court, your complaint is really general. You don't have to give a ton of detail. I give a ton of detail because I just like to, and I think it's more helpful, but you can just put, this person was in a car accident on this date and they were injured. I mean, obviously there's more to it, but you don't have to get into the nitty gritty of every injury and every theory of liability. But a bill of particulars is a document that you have to provide at a later date, where you more thoroughly set forth the theories of liability and each injury. And if you don't cover a body part, if it's not referenced in the bill of particulars, then you can't claim it later on. So it's crucially important to not miss anything, or just make sure that, okay, this was related, this wasn't related, this, this was an aggravation, this wasn't an aggravation. And I found myself going through medicals and sometimes, jumping ahead with the idea that, oh, this has already been repeated, but maybe there's some nuance or something that I missed. And that's a fear. So yeah, that's something that you guys.
So what you're saying, so that's
um,
what we find though, Blake, is like they'll have that detailed, like that initial consult, and then when they have subsequent visits for PT OT, they just kind of add on to that note. So you really have to dive into it to like look for the date of like usually it's under the assessment plan, and then hopefully they have a new entry, even though it's stacked onto that initial report. And that's what's frustrating. So we kind of know as legal nurse consultants to dive in there and look for that because it's an add-on.
Yeah. And I mean, I think it's important because for, like I said, on car accident cases, I'm always looking for objective diagnosis, range of motion, limitation of activity. So even if you're able to comb through and I tell you, okay, can you please summarize that stuff or just point it out to me so I can more thoroughly look at it and know where to look, then it's extremely helpful.
Mm-hmm.
Every IME I attend, the doc has the bill of particulars with them.
Mm-hmm. Yep.
And sometimes they'll admit they don't, and they're panicked. They're like, oh, I don't have the bill. All right, tell me what's wrong with you.
Yeah.
or what happened in the accident? Like, would you hurt yourself? Yeah, because they don't have the BOP.
Yeah, and I think, again, I tend to overdo it and put a lot more information and make it a lot more detailed than you probably have to be. I think as long as you give notice of, like, for example, neck, back, low back, leg, that sort of thing. But I like to go through, which is why you guys have been really helpful to know the exact diagnoses, and then find the exact diagnoses, and then just be able to put everything in there. Because again, I think it's all about information, and it's all about showing your evidence.
Name of the game.
Get a fair result.
Yes. I think we touched upon Michelle Jackson's kind of question here, but I thought we maybe just go over again.
Sure.
A little change of subject, Mr. Zaccagnino. How did you find your LNCs, and what type of marketing would you suggest for a new LNC? I think everything you've kind of already put on would show. Or go ahead and answer that, but you've touched a lot of that.
So I know that Tim was how his business initially started was through our paralegal Gail that's been here for 40 years, and she does an amazing job. And she was talking to you, Tim, right, about we don't need chronologies, but we want you to go to our independent medical exam.
Yeah.
You've helped us with that. And then it was kind of odd how we got reconnected was I was working on a constitutional law case regarding medical care in a jail, and another LNC was helping, who I found through LinkedIn, who had sent me a direct message, and then she was involved for a short period, and then had said, "Oh yeah, I have another expert, Tim Kane, who is more experienced in jail in medical care in a jail setting." Mm-hmm. But yeah. So I mean, I would say probably LinkedIn. I mean, it is kind of, which I know it's in every field where you deal with it, where you get a lot of like spammy sort of direct messaging. But I think if it's more of like a genuine, is there any way I can assist? Then yeah, I would probably say through LinkedIn, especially if it's a younger attorney too. I mean, I'm younger, so I'm not really going on paper ads or anything. So mostly emails and stuff. And it's like you almost don't notice it until you need it, sort of thing. It'll come in your head. Oh yeah, this person sent me a message. I should look into that.
I try to tell people that this is with LinkedIn. Everything's a marathon. It's not a sprint. Like, I sent you a message. How come you're not replying to me and asking me and giving me a case? It's like it takes a long drawn out time. Go ahead, Jen. I'm sorry.
All life is timing.
Yes.
That's really how it goes.
So yeah. And I think it's helpful to, in these direct messages or on LinkedIn, I think being specific about, okay, I have an expertise in, for example, Tim, like correctional nursing, or I worked in gynecology, or I worked in orthopedics or whatever. To then, that would be helpful to know, because then it'll stick in our mind.
Right.
Okay, we have a torn shoulder, so we need an orthopedic. So this person could help.
100%. Joanna has a follow-up question here. Thank you for answering my questions. You have partially answered my next question. I spoke with a paralegal at a very large personal injury firm of multiple offices. She said they don't need LNCs because they use paralegals and physicians. Where would I potentially fit in as an LNC and provide specific value? Yeah, we sort of did touch on that, but I'll let you talk about that, Blake, if you could.
Yeah, so I mean, I would just say, but if it's I would say you couldn't use a paralegal if it's a case where you need an expert opinion. So for that sort of stuff, you definitely need either a physician or LNC or someone that is an expert in the field. And then I would also, like we talked about how there might be some things that within expert medical eye that you see in the records that a non-trained expert eye wouldn't see. And that's really helpful to then be able to not miss anything. And you could really, not that you can't rely on office staff, but it's just nice to have someone with a expert eye look at it.
I like to tell nurses that they can say to the firm that they can put themselves at the bedside of your client's case where the paralegal can't. Well, we've been at this for almost an hour. We're at 50 minutes, 51 minutes. This is flew because it was very interesting. I mean, and it just had so much content and topics to it.
This is great. Thank you so much for always helping us and being responsive. And I know we kind of touched on that earlier, and I don't know if you want to talk about briefly just our experiences, but yeah, I mean, your offices have always been very responsive to my emails. And a lot of the times we get motions that are filed, and often a short window we have to respond, and we have to get affidavits, and we got to get everything together. And it's really nerve-wracking. So even to calling, I know that, Tim, I've even called you when I'm leaving the office at 7:00 because I'm panicking about something, and you're able to, and you generally will pick the phone up and you calm me down and say, yeah, we'll talk about this tomorrow. But I looked at it and you put me at ease, and just the responsiveness is huge. And even, getting affidavits that we need for expert reports and stuff, being prompt and responsive, that's huge.
Jen and I have a friend in this business that taught us that speed wins. You don't have to go fast to miss something, but you have to, if someone contacts you, the quicker you get back, the better off you'll be.
Yeah. Absolutely.
Oh yeah.
I have your email address at the bottom scrolling here.
Oh, awesome.
Yeah, but I want to apologize because I just realized something, that I just exposed you to probably 150 LNCs, and they're all going to be emailing you.
Hey,
and the next day saying, use me for, heck with that Tim guy. He doesn't know you.
Oh.
I know they wouldn't do that. I'm kidding. I have a great relationship with all of them, but that's cold email is common in the LNC world to get clients. So
yeah, and it's nice to have someone that's nearby too, because I know that we've had it where you say, oh yeah, I can pop in, I'll be in the neighborhood or something, and you're just you're available.
Right.
How can I put this on? Is this going to be recorded? And then
it is, and I will send it to you.
Oh, perfect. Okay.
Yeah.
And it's also going to be on my LinkedIn, but I also can send you the actual hard copy of it.
Cool. That'd be awesome. Yeah, and then I'll put it on my social media stuff.
Perfect.
That would be wonderful. If anybody wants to contact Jen and myself, we're at Medical Legal Connection. And here, I'm going to put my banner up at the end here. Here we are.
Thank you guys so much. It was so much fun.
It was fun.
Blake, this was a pleasure. And thanks. I mean, I really learned a lot today from you. Just like when you're explain the bill of particulars and like the supplemental, or what was that?
Summary judgment.
Oh yeah.
Yeah. I had it at the tip of my tongue, but anyway, I really appreciate all that you taught me today.
No, thank you so much. And it's, I look forward to collaborating and working together on a lot of cases in the future.
Absolutely. More to come.
Yeah.
That's my phone number. All right. We're going to end this stream, and we thank everybody for joining us in the audience, and everyone have a pleasant day and stay warm.
Thank you. Bye.
Thank you. Bye.
Bye.